This is the story of a man who walked into federal bankruptcy court claiming he was worth $4.4 million. The exact same week, a major financial magazine had pegged his net worth at $155 million. Curtis James Jackson III, known to the world as 50 Cent, did something in the summer of 2015 that most people had never seen a celebrity attempt. He took one of America's most powerful legal tools, bankruptcy protection, and deployed it not out of desperation, but as a deliberate financial strategy. To understand why it worked, we need to start where his money did. The rise and the money. South Jamaica, Queens, New York is where Curtis Jackson grew up, and by the early 2000s, after surviving a near-fatal shooting, he had assembled one of the most commercially successful careers in hip-hop history. Music got him in the door. What came next made him genuinely wealthy. October 2004 is when he made the move that would change everything. Rather than simply endorse a product, Jackson took an equity stake in a small beverage company called Glasso, the maker of vitamin water, in exchange for promoting and co-creating a flavor called Formula 50. Spokespersons get a check and go home. Part owners get something else entirely. What they got, in Jackson's case, arrived in May 2007, when Coca-Cola announced it was buying Glacio for $4.1 billion in cash. And that deal closed on June 7th of the same year. His reported after-tax payout sat somewhere between $60 million and $100 million, a range he has never officially confirmed because of a confidentiality agreement. But that single transaction turned a rapper from Queens into one of the wealthiest entertainers in the country. The money went to work immediately. G-Unit Records, G-Unit Clothing, SMS audio headphones, a stake in a premium vodka label called Effin, and a television production arrangement that eventually produced a Stars drama called Power. All of it came together into a portfolio that led Forbes magazine to estimate his net worth at $155 million. And then there was the house. In 2003, Jackson paid $4.1 million for a 50,000-plus square foot estate in Farmington, Connecticut that had previously belonged to boxer Mike Tyson, then poured roughly $6 million more into renovations. 21 bedrooms, approximately 37 bathrooms, a nightclub, a movie theatre, running on monthly maintenance costs of around $72,000, with utilities alone eating up about $18,000 a month. None of that looked like a problem when the money was flowing. That changed when he became a target. The feud, the tape, and the lawsuit. Understanding what unraveled next requires understanding the rivalry between 50 Cent and rapper Rick Ross, whose legal name is William Leonard Roberts II. Their beef ignited publicly at the 2008 BET Awards, and by 2009, Ross had released a track called Mafia Music that referenced 50 Cent and a woman in his personal life. What followed was one of the most aggressive feuds of that era in hip-hop, and 50 Cent chose not to keep his response within the music. Lastonia Leverston was the mother of a child fathered by Rick Ross. Back in 2008, she had recorded a private, intimate video with her then-boyfriend, Morris Murray, a tape that was never intended to leave that relationship. Somehow, that recording ended up in the hands of Curtis Jackson. At the height of the Ross feud in 2009, Jackson took that private tape, edited it, and inserted himself wearing a wig and playing a character he called Pimpin' Curly. Murray's face got blurred. Leverston did not. The tape went online, linked to Jackson's website thisis50.com, and he referred to Leverston as a porn star. She had not consented to a single frame of it, and she had no warning it was coming. Leverston filed suit against Curtis Jackson in New York State Supreme Court in Manhattan in 2010 under case number Index 102-449 of 2010. Her claims covered invasion of privacy under New York's civil rights law and intentional infliction of emotional distress. And her legal team built a case around the documented psychological damage the posting had caused. At trial, her words to the jury were direct. This was something done to me. I didn't have a choice. I would never, ever do this to myself. Psychological evaluations presented in court concluded she had developed major depressive disorder and symptoms consistent with post-traumatic stress. Her attorney, Philip Frieden, told the jury in closing, Maurice broke her heart and 50 Cent ruined her life. Jackson's turn on the stand produced a moment that a lot of people in that courtroom remembered. His version of an apology came out as, "I'm sorry if you feel that I hurt you." Then he winked. A Hot 97 radio recording was also played at trial, in which Jackson acknowledged that the Ross feud drove traffic to his website, which Leverston's team used to argue the tape had served a commercial purpose under New York law, strengthening their case considerably. The verdict. Years of litigation came to a head on July 10, 2015, when a Manhattan jury delivered its verdict. $5 million in compensatory damages went to Lastonia Leverston, $2.5 million for the unauthorized use of her image and likeness, and $2.5 million for emotional distress. The case then moved into its punitive damages phase, which is the part of a trial where jurors can go beyond compensating the victim and instead penalize the defendant for the conduct itself, sending a message that certain behavior carries consequences. Leverston's attorney asked for $15 million. Jackson's attorney asked for $700,000. The gap between those two numbers tells you everything about how each side read the room. 3 days after the compensatory verdict, on Monday, July 13, 2015, that punitive phase was halted before it could begin. The filing. 15 minutes before a scheduled punitive damages hearing was set to open in a Manhattan courtroom on July 13, 2015. Attorneys for Curtis James Jackson III filed a Chapter 11 bankruptcy petition in the United States Bankruptcy Court for the District of Connecticut in Hartford. Pullman and Comley, the law firm representing Leverston in the bankruptcy proceedings, later confirmed the timeline without ambiguity. Mr. Jackson filed his bankruptcy petition in Hartford 15 minutes before the start of a scheduled hearing on whether he must pay our client punitive damages. That gap was not an accident, and here's why it mattered so much. Under federal bankruptcy law, the moment a Chapter 11 petition lands with the court, something called the automatic stay kicks in immediately. It freezes virtually every legal proceeding against the filer. Creditors cannot collect, lawsuits cannot move forward, judgments cannot be enforced, and a punitive damages hearing cannot begin. Everything stops, including an award that Leverston's attorney had been asking a jury to set at $15 million. Jackson's petition listed total debts of $32,509,549. Against that, his claimed assets came to $24,823,899. The man Forbes had called worth $155 million was, according to his own court filings, underwater by roughly $8 million. And the punitive phase that might have pushed that number far higher had just been frozen solid. What Chapter 11 actually means. Chapter 7 is what most people picture when they hear the word bankruptcy. Hand over everything. A trustee sells it off. Creditors take whatever's left. Chapter 11 is a reorganization. The person filing stays in control of their assets and income. The legal term is debtor in possession, while negotiating a repayment plan under court supervision. The filer does not automatically surrender anything. For someone with ongoing businesses, a television career, music royalties, and multiple income streams, that distinction meant everything. California bankruptcy attorney Mark Marcus put it plainly. Chapter 11 filers are definitely not broke. What they are is insolvent. Insolvent means debts exceed assets on paper. Broke means the money is gone. Those are not the same conditions. Jackson made his own comparisons publicly. Walt Disney filed for bankruptcy before constructing his entertainment empire, and Donald Trump's business entities had gone through bankruptcy protection multiple times. It means you're reorganizing your finances, Jackson told reporters, then added the sentence that cuts to the core of everything. But it does stop things from moving forward that you don't want moving forward. The creditors and the context. Leverston's judgment was only one piece of the financial pressure building on Curtis Jackson in the summer of 2015. The largest creditor on his bankruptcy petition was a company called Sleek Audio, a headphone manufacturer that had entered into a business arrangement with his SMS audio brand. And when that arrangement collapsed into litigation, an arbitration panel ruled against Jackson for approximately $16,181,578, a figure that had grown to roughly $18.4 million with accumulated interest by the time the bankruptcy petition landed. SunTrust Bank also appeared as a creditor, holding the mortgage on the Connecticut estate. That 50,000 square foot property carried a listed value of $8.25 million in the bankruptcy filings, a number dramatically below the $18.5 million Jackson had asked for back in 2007, and below the $10.9 million he had dropped to in 2010 after finding no buyers. Years of price cuts and no sale, while maintenance ran at $72,000 a month and utilities consumed around $18,000 more. His court-filed monthly income came to $184,969 against expenses of approximately $108,000. His vehicles, a 1966 Chevrolet Coupe, a 2010 Rolls-Royce Phantom Drophead, and a leased Bentley Mulsanne, were collectively valued at roughly $500,000. Approximately $855,000 in child support remained owed to the mother of his youngest son. 8 days after the filing, on July 21, 2015, his attorney James Renard stood before the court and put Jackson's actual net worth at approximately $4.4 million, roughly 35 times lower than the Forbes number from just weeks earlier. Jackson walked into that same courtroom and offered the press a line they printed everywhere: "I'm not as cool as I was last week." The Instagram problem. Whatever legal precision had gone into the bankruptcy filing, the weeks that followed nearly destroyed it from the outside in. While telling a federal court he was worth $4.4 million and could not satisfy his debts, Jackson kept posting on Instagram as though the proceedings weren't happening. Cash appeared in stacks across his feed, and in one widely circulated post, the bills had been arranged on a surface to spell out the word broke, apparently as a joke. Other images showed cash sitting in his refrigerator and cash spread across his bed. A post announced he had purchased a home in Africa. Luxury vehicles turned up throughout. None of this went unnoticed by the people waiting to get paid. Creditors filed complaints, and United States bankruptcy judge Ann M. Nevins, presiding in Hartford, summoned Jackson to court to explain himself. Her language from the bench was measured and direct. "I'm concerned about allegations of non-disclosure and a lack of transparency in the case. There's a purpose of having a bankruptcy process be transparent, and part of that purpose is to inspire confidence in the process." Jackson's legal team arrived with an explanation. The cash, they contended, was prop money, fake currency sourced from a company called RJR Props, used as part of routine social media marketing consistent with the 50-cent persona. Jackson reinforced this in sworn testimony, framing his public image as performance rather than autobiography. "It's like music videos," he told the court. "They say action, and you see all these fancy cars, but everything goes back to the dealership." The cars in question, he testified, were rentals. A 65-carat ring visible in one post had been borrowed from the jeweler. March 2016 brought a new wrinkle when the Secret Service reportedly made inquiries about whether the currency in his photos qualified as counterfeit. Jackson announced on Instagram that he was stepping away from the platform over the scrutiny, a departure that did not hold. Meanwhile, juror Sylvia Rodriguez from the original Leverston trial had already said publicly what a lot of people were thinking. "He has it. He's 50 Cent. You know he has more than 50 cents." the resolution. Through all of it, the bankruptcy process kept moving, and by the end, it delivered something for nearly every party involved. 11 days after the filing, on July 24, 2015, the court had granted Leverston's emergency motion for relief from the automatic stay, letting the punitive damages jury reconvene. And that jury awarded her an additional $2 million, bringing the total verdict to $7 million. Winning the verdict and collecting it, though, were two entirely different problems, and collecting required going through the reorganization. Nearly a year after the filing, on July 6, 2016, Judge Ann Nevins approved a reorganization plan valued at approximately $23.4 million, requiring an opening payment of about $7.4 million and promising creditors between 74% and 92% of what they were owed. Leverston settled for $6 million, $1 million less than the jury's award, but money she would receive rather than spend years chasing through further litigation. Sleek Audio accepted $17.5 million to resolve a claim that had started at nearly $16.2 million and grew with interest. SunTrust was addressed through the reorganization as well. A large share of the funds came from a source nobody had anticipated at the outset: a legal malpractice settlement. Jackson had filed suit against his former attorneys, the firm Reed Smith and attorney Peter Raymond, alleging their negligent work had contributed to his financial troubles. That case settled, and approximately $13.65 million from it went directly toward paying creditors. Jackson's own lawyers told the Hartford Courant that a Chapter 7 liquidation would have returned creditors roughly half of what the reorganization ultimately paid them. Judge Nevins noted in her rulings that Jackson has a significant ability to generate income, which was, in a single phrase, both the reason Chapter 11 had worked for him and the reason a lot of observers had never believed the insolvency claim to begin with. February 2nd, 2017, 19 months after the filing, the bankruptcy received its discharge. Curtis Jackson had paid his debts and walked out legally cleared. What happened after? The discharge turned out to be less an ending than a starting line. In 2017, Jackson reportedly sold his stake in Effin' Vodka, announcing the deal on Instagram with his usual restraint. "I got the bag. Effin' Vodka. Can you say $60 million?" The brand's parent company disputed whether he had fully exited the arrangement, but even a partial sale at that reported figure would have recovered everything paid out through the bankruptcy and then some. The Connecticut mansion, 50,000 square feet of former Mike Tyson estate that Jackson had bought for $4.1 million, renovated for $6 million more, and carried at ruinous monthly cost for over a decade, finally found a buyer in 2019. That buyer paid $2.9 million, less than Jackson had originally paid for the property and a fraction of the $18.5 million he had asked for in 2007. Power on Stars expanded into a full franchise with multiple spin-offs, and in 2018, Jackson signed a 4-year overall deal with the network reported to be worth an estimated $150 million. A G-Unit final lap tour reportedly grossed over $100 million in ticket revenue. The man who had once sat in a Hartford federal courtroom and told the world his net worth was $4.4 million had, by any available measure, rebuilt. The bigger picture. What this case taught us. What happened with 50 Cent's bankruptcy raises questions that go well past one celebrity's money troubles. Bankruptcy protection in the United States was built for a clear purpose: to give people and businesses overwhelmed by debt a path toward resolution that treats creditors fairly and gives the debtor a genuine chance to recover. The system exists because societies generally get more out of economic rehabilitation than from simple punishment. And yet, the same tools that protect a family from losing everything can, in the hands of a skilled legal team, function as precision instruments in a financial negotiation. The automatic stay does not ask why you are filing. Desperation and strategy produce the same legal result. The clock stops either way. What this case made plain is that Chapter 11 can operate as a negotiating platform just as readily as a rescue mechanism. Filing forced every creditor, Leverston, Sleek Audio, SunTrust, into the same court, on the same timeline, under the same judge. Leverston, who had won a jury verdict and stood minutes away from a punitive damages hearing that could have produced a much larger number, found herself in a bankruptcy courtroom in Connecticut instead. She received $6 million. Whether that constitutes justice depends on whose position you occupy. Her legal team did secure something that mattered: a court-supervised, documented repayment process that produced real money rather than a judgment that might have taken years to enforce. And as Jackson's own attorneys acknowledged, Chapter 7 liquidation would have returned creditors roughly half of what the reorganization actually delivered. When the case closed, Leverston offered a statement that carried the full weight of everything she had been through. "I am extremely proud and thankful that my team helped me find the courage to stand up to a man who took advantage of and humiliated me in front of the entire world. I've been served justice by the courts and vindicated by God." This is a story about money, but the money is really just the vehicle. What Curtis James Jackson III actually demonstrated is how power operates, who holds it, how they use it, and how tools built to protect ordinary people can be turned by those with the resources and legal firepower to do so. 15 minutes before a punitive damages hearing. Prop cash on Instagram while creditors waited. A $7 million verdict settled for 6. Out of bankruptcy in under 2 years, then a reported $60 million vodka sale shortly after. Not one step of it was illegal. The woman who was wronged received payment. The man who wronged her remained wealthy. And the system worked exactly as designed, for the person who understood it best. If this video made you think differently about how the law actually works, subscribe. There are plenty more stories like this one waiting.